Welcome to Florida is Our Domain.
Hey everyone, welcome into an all-new episode of Florida is Our Domain with Anthony Policastro. I am your host, Mike Leon. You know, Tony here is a Florida eminent domain attorney, the founder of the Policastro Law Group. He's got 30 years of experience in the field, representing national corporations, business owners, and individual landowners all across the state of Florida. Today, we're joined again by Jared Silver, who's also an eminent domain attorney over at the firm. And before joining there, Jared actually spent 7 years handling eminent domain cases for the Florida Department of Transportation, and earlier in his career served as lead counsel in dozens of jury trials all across the state of Florida, in Broward County specifically as an assistant state attorney. In today's episode, we're going to be talking about what happens when an eminent domain trial actually goes to trial, right? The case goes to trial. From preparing that evidence, how the jury evaluates the impact on a property or business. These guys are going to break it all down in just a second. Guys, it's good to see you as always. Jared, I'm going to start with you on this episode. So I just mentioned your background, your experience. You tried so many jury cases. So from your years as a prosecutor and at FDOT, when that eminent domain matter is heading towards a trial, what are some of the early steps that kind of set the foundation for a successful outcome?
Well, thank you for having us, Mike. When it comes to jury trials coming up, one of the first things you do is you have depositions of all the witnesses for the other side, all the experts, and that's done in person with a court reporter. It's usually voluminous, takes hours because you go through every single thing they've written or opined on one by one. You may have some history with them and know things they've done in the past. Okay, does what you say here conflict anything in the past? So you put them on record and put them into a position where if they testify differently at the trial, they will look not credible to a jury. Another step you do is you do some pretrial motions. So what are called motions in limine, and that's to limit information to get into the trial that should not be a focus of the trial, that is irrelevant information. And you want to do that ahead of the trial so that it's not a surprise where it comes up in the middle of the trial. And it's think of Law and Order where somebody says something, it's like, objection, chambers, and you want to avoid that. So you do that beforehand so it stays out and there's no surprises in the middle of the trial. Also, one thing we like to do is for appraisers, they'll do how they evaluate property and the worth is having comparables, comps to the property in question. So we like to go out to the comparables. It'll be usually 3 or 4 per property. So you're visiting 6 to 8 comparable properties for 3 or 4 for each appraiser, the property owner appraiser and the condemning authority appraiser. And we like to do that as well. And so all that preparation can lead to a very successful outcome.
Well, it's a lot of preparation, it sounds like. And Tony, not every case obviously goes to trial. So take me inside when you're evaluating a file. What are some of the situations that tend to signal that I don't think a negotiated resolution is possible in this instance?
Usually when you're at mediation with the client, there's a range on how you can settle an eminent domain case. Usually at this point in my career, I'm pretty good at knowing that range. Usually that range is about $50,000, in larger cases. So it's a pretty tight range. You want to try to get into that range. You've evaluated that case with your client beforehand. You've evaluated it with your own team of experts. Of course, the DOT has done the same thing on their side of things. I find that typically the trials I've had is because there is just a completely misunderstanding, if you will, I'll be nice, about the case. And it'll be that, for instance, the government side absolutely just doesn't give your side a lot of credibility and they don't go up a lot in mediation. And so it makes it rather easy. I always tell the clients this because they're always like, well, when do we know about going to trial? And I said, often through the negotiation process. When you do mediation, it takes rounds of negotiation in eminent domain. When I say rounds, it's easily 8 to 12 rounds of back and forth with the mediator, going back and forth from one room to the other with counteroffers. Sometimes I've been in mediations where it's 20 plus offers. Sometimes I've been in mediations that have gone to midnight, starting at 10 o'clock in the morning. And what you find is if you find that the mediator tells you early on that the government side is slowing down already, and they just kind of stop and give you their their best offer, essentially, maybe around three or around during round 3 or 4, and it's a fairly low offer and it's not close to the range, then you know that if you believe in your case, which I do, then it's time to go to trial. It's time to impasse the mediation, and as Jared had mentioned before, it's time to start up intensive discovery process. Start looking to set up depositions, do your motions in limine, and get ready to go to trial.
Jared, let's talk about that component of now going to trial. There's multiple experts that are going to be involved. Let's talk about some of them. And you got engineers, you got appraisers, you got planners. How does all this testimony kind of fit together for a jury that may be hearing some of these concepts for the first time?
Yeah, that's a good question. And trials are really a story. Each side is pitching a story in a sense. And so first, for us, we would have the engineer come in and really set the picture up. So they're going to tell us what the project is, why, what it's for, but also set up how it's going to affect our client, the property owner. All the things that are going to go wrong as a result of this, all the parking that's going to go on, the access that's gone, the circulation, all those things, the engineer is going to tell us about what will happen. Then we'll come in and we'll have the land planner so that we can tell the jury, this is the potential of this property and before and after condition. That, oh, sure, it might be just a piece of agricultural property now, but its highest and best use is actually for a commercial purpose. It can be rezoned and it can become a gas station. It can become a small shopping center. And because obviously the more intensive of use it is, the higher value. So the land planner will do that. Then to tie it all together, after we set all that up, we'll have the appraiser come in and give, this is what the amount is worth. We set everything up for now the appraiser to put the crown on it and tell us exactly what it's worth, because that's the last thing we want to leave with the jury, what the number is, because that's the decision they're going to make. The only decision they're going to make is about the money. And also if there's business damages, we'll also have an accountant come in before the appraiser and give their testimony as well. Again, after the engineer and land planner, because this is how the story is told. We tell you the calamities, we tell you the possibilities, and then we tell you the amount we want.
Tony, let's talk about the money, as we did in the last episode. So obviously you get competing valuations here in this back and forth. How do you personally help these jurors kind of understand the reasoning behind the owner's position versus the numbers that differ from the government's position?
Well, what we do again is it's hiring the right experts, very good qualified experts. I like to hire experts that, yes, they may mainly do property owner work, but they may do some government side of the work too. I think it adds a lot of credibility if you've got somebody that doesn't do just one side completely or the other. And I like people that can explain, as Jared said, tell a story up there, because that's what you're trying to do. You want to create a theme for the trial, and you want to have a through line through all your testimony. Usually these eminent domain trials last about 5 days. And so you want to have that theme running through, picking the jury, your opening statement, your testimony from your engineer, your appraiser, and some supplemental witnesses as well, where they understand what is going on. And then, of course, we're in a visual world today. So exhibits, PowerPoints, those sort of elements are key to getting the jurors to understand. And it's difficult. Frankly, eminent domain is a lot of tedious testimony, could be somewhat boring in the sense that you're dealing with a lot of numbers, a lot of technical. And so you've got to try as best as you can to break that down clearly and concisely in a fashion, not so much entertaining, but in a fashion that's very understandable for jurors to relate to. And also, it can be very important to put your owner or a business owner or property owner on the stand to testify, because I do think that that person is very relatable for the jury.
Yeah, I would agree with that. Jared, let me ask you something that Tony just mentioned there about exhibits and diagrams and stuff like that. Obviously, you want to break up the monotony in that courtroom, right? What in your experience handling cases like this, what makes a visual presentation effective, or does it make it effective in helping these jurors kind of understand everything going on with respect to the case?
Thank you. Great question. And I think it does make. I think it makes all the difference in the world. Picture is worth 1,000 words. That's the old saying, and it's absolutely true. So when we do a trial, we want to convey to the jury, and we have all the exhibits of what is the property like before the taking, and what will it be like after the taking, and what could it have been without the taking. The possibility when we talk about the highest and best use. And we want the jurors to have those images. And we also want to show, okay, what's the area surrounding the property look like as well? Because if there's, again, our property might be, let's say in this example, agricultural, but all around there might be a lot of businesses and schools and houses. And so the highest and best use we know is a part of a community that has a more intensive development than agricultural. So we want to show that as well. And another thing I'll add is a unique feature of eminent domain trials are the jury actually gets to go out to the site. It's a site visit. So really all the jurors just get on a bus and they go out to the actual physical property that's being taken and they walk around it. And so I can't say enough about it. Visual matters so much, especially in eminent domain.
Gents, as we put a bow on today's episode, and Tony, I'll start with you, and Jared, you can piggyback if you want. In both of your opinions, what is the most effective in front of a jury? Like, what's been the most effective thing for you guys in front of a jury in terms of getting that favorable result?
I think for me is trying to make sure that you're very relatable to the jury. I think coming across speaking less technically right in more common language that we all use. I think that's important. I also think that aerials of the property and the surrounding location is very important. And also charts that show where all the sales are laid out. Often that's important to show that what sort of unique characteristics are part of your sales, but also where the locations are, the sales are, vis-a-vis where the subject property is. And I also think, aerials are, very helpful to just show the highest and best use of the property and what's going around the property and what is being developed around the property. And then finally, I'd say one of the most important things really is picking the jury. So it is very important to give a thorough voir dire, which is, to basically the technical term of picking the jury and questioning them and finding out what their prejudices might be, what their biases are ahead of time. And I know Jared's very good at doing that as well.
Yeah. Jared, piggyback?
Yeah, I 100% endorse what Tony just said. Just speak more in depth about the voir dire process. For as an example, in my last trial, there were a number of jurors that were prejudicial to my client's position. And through the questioning, I was able to exclude, I believe, my memory serves me, 7 to 8 of them, just before we had to use any of our limited selections, just on their own prejudice. So, which is an unlimited amount of jurors you can get off the jury panel. And I was able to do that for quite a number of them who were very prejudiced against my client's position. And so I happen to think jury selection is the most important part. Your jury makeup is the most important part of every trial. Obviously, what Tony says, I agree with as well. And to circle back to my last answer, the site visit in an eminent domain trial also is invaluable as well. So I'd say jury selection and site visit.
And Mike, just to add real quickly, what Jared's talking about is you can always knock a juror off, a potential juror, for cause. Mm-hmm. And that's what he's saying. He was building a case on 7 or 8 of those to knock them out for cause. And then there's always peremptory challenges, and there's 3 of them in an eminent domain jury trial that you can just basically get rid of somebody without stating a cause, as long as the cause is not blatantly, let's say, racial or something that is, you can't just exclude somebody on that basis.
Gents, thank you for the time, the insights, breaking down this intricate topic. As always, I appreciate it, guys.
All right. Thank you so much. Appreciate it.
And thank you to everyone out there for listening to this installment of Florida is Our Domain. If your property or your business is being affected right now by a public project, Don't go at it alone. I know 2 lawyers that can help you with that. Visit policastrolaw.com to schedule a consultation with the team and learn how Tony and the guys can help you guys. Don't forget to like, subscribe, leave a review, and comment. Share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.